Great. Thank you very much.
It's a little embarrassing to hear my history. It's kind of a checkered past, as you can see, and one that one would wonder how leads to being a legal counsel for an association, but it actually meshes very well with the background, the litigation side. When I was at United and left United, the general counsel paid me the compliment of saying when they didn't know where something should go, they would send it to me. And you had to address it as flexibly as you could. And I found the same thing with the association work and with ADA. I hesitate to liken crisis management to working for the ADA, but sometimes it feels a little like that. But it did give me a wide range of experience, which has suited me well, because in an association, you never know the kind of legal issue that's going to walk in the door. And it's a lot of fun. I am honored to serve as the Chief Legal Counsel for the American Dental Association. It is a terrific organization, and one of those places where you never have any hesitation of telling people where you work, because it's a terrific mission, and you guys are doing a great job. The message that I try to convey when I speak to groups, as I told some of you, is that I want you to treat us as a resource for your organization. Our job is to address issues for you and for the members of the ADA and for the constituents as much as we can. So Terry and I have had conversations and exchanges of correspondence, which I hope he's found to be helpful. Our idea is that if we can't be your lawyer, I'm the lawyer for the ADA, and I can't represent individual members, but we can discuss legal issues with you. We can give you some direction as to things you ought to think about, things of that nature. And I just really enjoyed the opportunity to work with some of you. Ted and I have worked fairly closely on some issues, and it's been very, very gratifying. I want to hit a couple of issues that may be of interest to you today, and if I start to run too long, Roger, just pull me off the podium, because it's very dangerous to give me a microphone, as my wife has told me many times. I know one of the things that you have faced as practitioners that is very frustrating, and I share with you the frustration. It's very frustrating for us as well, and the message I give you is not one of great solace, but more to tell you we recognize the issue, we're trying to see what we can do about it, but it's a very, very tough issue, and that's the third-party reimbursement issue. Dealing with insurance companies is very difficult in any context, but when you're being reimbursed as a healthcare provider, we understand the frustration, because it's a one-sided game at this point. And I've told a couple of you that one of the problems we have is that the insurance companies and the insurance industry are like a black box. You know, you really don't get inside to see how they function or how they collaborate or what kind of agreements are there. And if we have the opportunity to do that, if we ever can find that there is any questionable activity going on among the insurers, we would take that opportunity to go after them in litigation and try and get some discovery on what kind of agreements are going on. Although the McCarren Ferguson gives the insurance company some protection, it doesn't give them absolute protection. So if they were agreeing, as competitive organizations, if they were agreeing on the capitation rates or the reimbursement rates and things of that nature, that would be a violation of antitrust law. That's where we are. Now, early on in my practice and before, the antitrust laws were not viewed to have applied to healthcare providers. There was a generally kind of recognized profession exception to the antitrust laws. We're a profession, we're not a business, we don't have to be governed by the same kinds of laws. In the early 70s and beyond, that began to change radically. And the enforcement agencies began to take a look at healthcare, because healthcare became a business, because it was very clear that this was a huge segment of the commercial enterprise. And so the enforcement agencies and others began to look at the lawyers and the way that they function, the doctors and the dentists, the way they function. There was litigation early in the 70s over restrictions on advertising by lawyers that gave the Supreme Court the opportunity to say, no, can't do that. That's commercial speech, and you as lawyers, even though you're professionals, are governed by the same kind of legal restrictions as any businessman would be. Gradually that's evolved over the last many years, as you've all seen. In 1996, the healthcare provider became such an issue for the enforcement agencies that they issued a series of statements to say statements of antitrust enforcement policy in healthcare. If you haven't read them, you can Google it, you can go on the website. There are only 7 statements, and it's a little bit enlightening as to how they approach this. There are only 3 or 4 that really affect us. But one of them, or a couple of them deal with enforcement policy on providers' collective provision of non-fee related information to purchasers of healthcare services, and enforcement policy on providers' collective provision of fee-related information to healthcare services. Now, where these come out is that they establish a safety zone for healthcare providers in what you can do in dealing with your insurers. And what they say is, look, there is some information that you can share with the insurer which is very pro-competitive because it gives the insurer the ability to understand the marketplace, understand how the coverage should be provided and how you function. There is a line in some of these that we'll talk about that you can't cross over because you get into what they would consider to be an antitrust issue. Now, I may be preaching to the choir, you guys may know this already, but the antitrust laws came into effect in about 1890, an act called the Sherman Act that has been the primary law in antitrust for the last, that's where we are. Now, early on in my practice and before, the antitrust laws generally kind of recognized profession exception to the antitrust laws. We're a profession, we're not a business, we don't have to be the same kinds of laws. In the early 70s and beyond, that began to change radically. And the enforcement agencies began to take a look at healthcare because healthcare became a business, because it was very clear that this was a huge segment of the commercial enterprise. And so the enforcement agencies and others began to look at the lawyers and the way that they function, the doctors and the dentists, the way they function. There was litigation early in the 70s over restrictions on advertising by lawyers that gave the Supreme Court the opportunity to say, no, you can't do that. That's commercial speech, and you as lawyers, even though you're professionals, are governed by the same kind of legal restrictions as any businessman would be. Gradually that's evolved over the last many years, as you've all seen. In 1996, the healthcare provider became such an issue for the enforcement agencies that they issued a series of statements to say, statements of antitrust care. If you haven't read them, you can Google it, you can go on the website. There are only 7 statements, and it's a little bit enlightening as to how they approach this. There are only 3 or 4 that really affect us. But one of them, or a couple of them deal with enforcement policy on providers' collective provision of non-fee related information to purchasers of healthcare services, and enforcement policy on providers' collective provision of fee-related information to healthcare services. Now, where these come out is that they establish a safety zone for healthcare providers in what you can do in dealing with your insurers. And what they say is, look, there is some information that you can share with the insurer which is very pro-competitive because it gives the insurer the ability to understand the marketplace, understand how the coverage should be provided and how you function. There is a line in some of these that we'll talk about that tell me a certain number of, and I'm going to buy those. That restrains trade because I can't sell it to somebody else and I can't buy it from somebody else. But it's not an unreasonable restraint of trade. And over the years, the courts have looked at this and they said, okay, let's look at the conduct that comes before us and figure out whether or not it violates this provision. And there is an old expression that goes way back that Adam Smith, the economist that some of us may have heard about when we took our basic economics courses in college. Adam Smith had a statement that basically said, when you get competitors together, whether it's for frolic or fun or discussions of any kind, ultimately it's going to lead to a price agreement that does not benefit the public. That's kind of a jaded view of the world, but that's what he came to, that anytime competitors get together, they're going to conspire. So that's kind of the background that you come from. So over the years, there have been a number of things that the courts have looked at. And the courts have said, okay, some things we look at and there is just no possibility of redeeming value. If 2 competitors get together at a price that they will charge for goods, that's what we call a per se violation of the antitrust law. We don't have to look any farther. We don't have to see what the effect on competition is because we know that's a per se violation. If 2 competitors get together and divide the market, We say, okay, national in scope, but you sell to everybody east of the Mississippi, I'll sell to everybody west of the Mississippi, we won't cross over the Mississippi. That's a per se violation of the antitrust laws because you're depriving the consumer of the competition that they're entitled to. So certain practices like that are per se violations. There are other things that have come before the Supreme Court where there's a vertical restriction on the output of goods. For example, a manufacturer tells his distributor, you can't sell in a certain territory, you can only sell in a certain territory. They've looked at that over time. Originally that was per se illegal. Now they've said, the economists have said, well, there are some values to that pro-competitively. We're going to judge that under what's called the rule of reason. I always kind of thought the rule of reason was a wonderfully self-named thing that lawyers come up with to make it sound much more euphemistic than it was. But still, it's the rule of reason, which means we'll look at the pro-competitive benefits, the anti-competitive aspects, and determine whether or not that's a violation of law. Okay, so that's where we can come down. Price fixing is per se illegal. What they've done in the statements of enforcement policy on healthcare is to show a concern for the ability of healthcare providers to get together and either fix prices or to use their market power to require a purchaser to come to a certain price level. So at the backdrop of all these things that you'll see that the FTC so they say purchasers of the healthcare. You can get together collectively and you can share that information, you can negotiate with the insurer, which is the purest. You cannot say plan. We will essentially boycott your plan. Because again, they're coming back to the point where they're saying you are collectively asserting yourself as market force and you are dictating what's going to be done in the market, and you cannot do that as competitors. Now, it's always kind of a surprise for professionals to realize that the enforcement agencies look at you as competitors, because in many respects you don't think of yourself as competitors. You think of yourself as colleagues, you think of yourself as a profession that is trying to do good things for the public and for the practice. But the way the FTC or the Justice Department looks at you, it is as competitors. So you can do certain things in the non-fee area pretty easily. You can get a lot more aggressive there as long as you don't threaten boycott. On the fee side, if we're talking fee information, there is information collectively that you can share with the insurers and you can talk about. There are some ways you have to do that, and we talk about the same survey among your association. The antitrust laws say you can collect a group of dentists getting together and collecting current information or prospective fee information that you're going to use that for purposes. And third, you have to make sure if you're collecting information that no single entity satisfies more than 25% of the survey. You have to have a large enough body of people who are being surveyed so that we have, you can't specifically identify who the pay information. They'll tell it to you so you can collect the information other ways, but they don't want that collected collectively. And you should aggregate the information so that nobody's specifically identified. If you have that fee information collected in that way, you can go to the insurers and say, look, here's what we're talking about here. This is, and maybe you say, look at the overhead rates we've got here. Look at the way the market functions here, and maybe you guys as insurers should take action based upon this. Now, where we are caught short is we cannot take that next step, which is action that you take is expressly prohibited by the antitrust laws. And that's where you come out. And that's the frustration we all have, is that we all feel that the insurance company has all the cards. We have no ability. We can go individually. Each of you can go individually to the insurer and say, this reimbursement rate is totally out of whack. You really need to raise it. And you could have 30 people do that individually. But you can't, and each one of those individuals could threaten to withdraw from the plan. But you can't do it collectively. And if it looks like there's a campaign to do that, then the FTC would come in and take a look at it. There have been a couple of instances. What I find now that I'm with the American Dental Association is I hadn't focused on the fact that the dentists are some of the most aggressive in getting hit by the enforcement agency sometimes. There was a group out in Arizona about 20 or 25 years ago, 20 years ago, that decided that they had a problem with the capitation rates, and they thought they were being mistreated. So there was a dentist in Arizona who got a group together and said, look, this is a real problem. Let's all send letters to the insurance company. And they sent letters to the insurance company saying, we really think you need to allow us a higher capitation rate. But the problem with the letters was they also said, and if you don't, we'll consider dropping out of the plan. And it was a letter writing campaign. They were all identical. In that instance, the Justice Department came in and charged those dentists with criminal conduct. They instituted a criminal proceeding against them. That's very unusual for a criminal proceeding to be brought. Often you'll have a civil case brought, and there are civil penalties that go along with that. But this was the only criminal case that we're aware of. And they actually got to the point where the jury came in and found a violation of the antitrust laws and assessed a criminal penalty. And the judge, fortunately, said, you know, I think I must have misinformed the jury, because this is just not a criminal proceeding. This is not a price fix. It's something that is definitely prohibited by antitrust law. This was an effort to have prices raised, but you really weren't fixing the prices. And so I'm going to order a new trial. At which point the Justice Department went to the Ninth Circuit Court of Appeals on appeal, but fortunately the Ninth Circuit came back and said, no, this should not be a criminal kind of proceeding, and so they watered it down considerably, and ultimately I'm not sure anything ever came of it, but it was one of those things that shows you that justice or the FTC can take a look at what you're doing and focus on it. There was a case several years ago called the Indiana Federation of Dentists case, where the dentists, in response to insurer action, said, well, you know, we're just not going to do this, so we won't provide the insurers with x-rays. Just won't do that. That's what we're going to do. We'll make this a little difficult on them. So when they asked for x-rays, none of us will provide it. And again, the government came in and said that's illegal under the antitrust laws, because it's joint action geared toward increasing the price of health care. So there's that component that goes along with it. So the collective action is a very difficult issue to address. And I think this group maybe have heard of perhaps alternatives where you can have an IPA, or you can have what's called the messenger model, where you have a group of dentists who are either integrated or not, who can deal through a messenger with the insurance company on an individual basis. It's a positive thing. It's a good thing, because at least you have a way of communicating as a group, but not as a group with the insurer, because they can hear a lot of views. But again, you're stopped short because you can't engage in that kind of group. There was a temptation to cross over the line. And there was a group called Southwest Health Alliance that recently fell victim to a consent decree by the FTC. And what was disclosed in the consent decree was that this is an organization that had been founded about 10 or 15, had operated on the Met a long time, but someplace along the way, they began to cross over and consult among themselves as to the prices they were going to ask for. So although they were using the messenger model, they were also collaborating as to the price they were going to ask for, and the FTC said that's wrong. You crossed over the line, you can't do that. So all these mechanisms are good to try, and they're good, but any of them you need to work with an antitrust attorney to make sure that you don't cross over that line. Now, the FTC does make a greater exception if the IPA, or the group of dentists or group of healthcare providers, is an integrated group. And by that they mean you share the risk together. You have the same procedures. You essentially function almost as a corporate practice, because you have a group of people all dealing through the same thing. In that case, the FTC says you may be treated as an individual entity, and you can negotiate collectively with the insurance company. But again, the problem is you take on the burden of the integration, and you give up a lot of the independence of your practice. So there's a flip side to both those things. And as I say, it's very frustrating for us. I've talked to the general counsel for the AMA, who went through these same issues before we did, and he had the same level of frustration. As a matter of fact, they had a lot of input into the guidelines that were published by the FTC and the Justice Department back in 1996. And a lot of these things were changed by virtue of their input, so it's not as aggressive as it once was. But we still have the same problem, and we share it with the other healthcare providers and the dentists and so forth. So that's basically my presentation on that issue. We are looking to see if there are ways. We're always open to the possibility of going after the insurance companies somehow, trying to attack this practice, trying to do something about it. As we've said, it cries out almost for a legislative solution, or a solution through the insurance commissioners. But the problem is, anytime you walk in with this issue to a legislator or an insurance commissioner, they're going to say, well, I mean, as I understand it, what you're doing is proposing something that would raise the cost of health care. And you say, well, yeah, it does, because it will more appropriately compensate us for our service. And they'll say, you know, we're just not going to touch anything that raises the cost of health care. That's just not a popular topic for any of us. So that's the frustration we have, and that's where we are. Yeah.
understand you can't share fee schedule information with competitors, essentially.
Mhm.
At what point do they stop being competitors? Like if I'm in Virginia Beach, can I share fee schedule information with somebody in Southwest Virginia? We have no possibility of essentially being competitors. Is there a geographic?
One of the elements of the antitrust laws is you always have to have market definition. So yes, if you're not an actual competitor, if you don't compete in a particular marketplace, yeah. If you have somebody in California and say, what are you charging out there for this service? Because I'd like to get an idea of how you got that. That shouldn't be a problem for you.
Is there any definition of how close California is?
Oh, no. That would be too easy if that were done.
Yeah, right.
No, what it is that the enforcement agency or the court will look at it to see the realities of the marketplace. But if you're talking a geographic area where there's no crossover, where you're so far apart geographically that there's no real legitimate chance of commitment, shouldn't be an issue.
And what about interspecialty? I mean, would that be looked at a procedure code if it didn't do the same procedure?
Yeah, but then the issue they'd say, well, why are you asking the question if you're not going to for that purpose? But yes, again, all these things are factors that they weigh into, whether or not you're violating the law. But it's something that a lawyer can walk you through, and the specialty areas might be a good distinction because you're not really competing with somebody in different specialty. But yeah.
The messenger model.
Yep.
What advantage as an organization do we have if, say, the insurance company says, we have all the dentists we need. We're not going to negotiate. I mean, is it a waste of time, money, efforts, or?
I think it's hard to say. I think it depends on the individual situation, and it's something you need to walk through with your lawyers to see where you can go. Most insurers are going to listen to you. Most insurers are going to, they may not do anything, but they'll always give the pretense of listening to you or taking the calls or taking the correspondence, and you hope you can do it. I've always said that a lot of these issues would be resolved if you were dealing with reasonable insurers, but I'm not sure that reasonable insurer is not an oxymoron, so because they have their own interests. And I've heard, and you guys are more familiar with I than this, but I've heard that a lot of these actions by the insurers are being done in anticipation of the exchanges that are going to be required under Obamacare. And I don't quite understand the relationship, except I think they want to be competitive with the exchanges, and they think they can do that by having lower rates. So, but again, it's something to walk through. I wouldn't discourage you from considering any of these models, any of these opportunities, because I think that anything you can do to establish a dialogue with the insurance company is not a bad thing. Now, second point that I would make is you're all familiar, since we've segued with the FTC anyway, you're all familiar with the North Carolina Board of Dental Board case that has now spun through. I don't know if you know the whole procedure, but what happened in North Carolina was that the North Carolina Dental Board had a regulation against tooth whiteners, and they sent out what they call cease and desist orders to a number of people engaged in tooth whitening. The fact that they sent orders becomes important later on, as you'll see, but it really is a meaningless distinction. They were authorized under state law to institute a lawsuit or to go to the Attorney General if someone was practicing dentistry without a license, and their perception was that the whitening that was being done was dentistry without a license. The FTC looked at this and said, no, what you're doing is eliminating competitors from the marketplace in an unreasonable way. Now, to step back for a second, you have to understand that the FTC has expressed the view that dental boards or medical boards or chiropractic boards, professional boards set up by a state, are in fact boards of competitors that have a financial interest in the outcome of what they're doing. A totally jaded view of the world, which I think, for all sorts of reasons, we think it's inappropriate. But that's where they come from. They're going to question anything a dental board does because they think it may not be in the interest of the public, it's in the interest of the financial interest of the people that are dealing with the issue. So where they come from is that they're going to look to see if there's any, and to give you a little more background, under the antitrust laws through the Supreme Court have been determined not to apply to action by a state, which is appropriate. If a state is taking action, you say that's what the state should do. And the antitrust law should not present for you to do that. There's no commercial interest, it's a state interest, it's a federalism issue. So if it is state action, it is not actionable under antitrust laws. But the FTC found that the boards did not qualify as state agencies or acting as state action because they were not sufficiently regulated by the state or supervised by the state, or that their authority that was given by the state was not sufficiently precise that it falls within that state action exception. We think this is wrong. We have an outside counsel who's a very knowledgeable antitrust lawyer who said, yeah, that two-pronged test is utilized if you have an agency that is delegated by the state to do something that the state ordinarily does. In this case, this is a state agency. This is a state group that is formed in pursuant to a state statute and specifically authorized by the state to do what it's doing. So why is this not state action? And that's one of the arguments that the North Carolina board is going to make once it gets the opportunity to do so. Now, where it's gone is once the FTC found out about this, they went to North Carolina and said, we think this is wrong, you better stop it. And North Carolina said, yeah, I got to pound sand. And FTC said, we're going to institute an enforcement proceeding, which they did, and North Carolina said, don't pound sand. So they went through the process, and the process they went through was one of the commissioners wrote an opinion that said, this is not state action, we think this is outside the state action thing. So they got that as a basis. Then they gave it to an administrative law judge who held a lot of testimony on whether or not this was a reasonable restraint, whether the tooth whiteners in fact posed a public risk, whether this was properly within the jurisdiction of the board, and not surprisingly came to the conclusion this violated the law as the FTC had said it did. It goes to the ALJ, and if you think this is a fair process, it's one that's burdensome and you have to go through, but it will not surprise you that the next step was to go to the full commission, the 5 commissioners, who ruled on the ALJ proceeding and said, oh yeah, ALJ was right, this is a violation of the law. That's where they are now. But fortunately, the next step that the North Carolina Dental Board has is to go to the 4th Circuit Court of Appeals to make their argument. And that's our now, and they're going to make those arguments, and we're going to file an amicus brief that supports them in those arguments to try and convince the court that yes, this is state action, number one, and should not be something that should be regulated by the FTC. The FTC doesn't really have jurisdiction on it. And I think there's traction there because this is one of those federalism issues. There are state issues, and there are federal issues, and the Fed guy should not be getting involved. Now, as a backdrop to that, you should know that Congressman Burgess from Texas has taken an interest in this issue and got together with our staff in D.C., Mike Graham, whom you may know in our advocacy office, met with Mike and some other representatives of other healthcare associations and said, you know, I don't like what's going on in the FTC. He said, I've drafted a letter that I want to send to the FTC that says this is a states' rights issue, you shouldn't be doing it. And secondly, under your enabling statute, you don't have authority over dental boards. And I want to try and get the support of other congressmen to send to the FTC. That's still in process, as I understand it. I haven't checked it recently, but the idea, we signed off on it. We said, that's great, but go for it. We understand that Congress Burgess had gotten the support of other congressmen to do this. And that would be a good first step by the legislature to try and limit what the FTC is doing. The next step, obviously, if you can interest the Appropriations Committee in supporting the FTC's finances to say, yeah, if you're going to do that, we're just going to cut your funds because you can't really afford to do that. So we have some support, we have some interest in going forward on that, but that's one of the issues that we're trying to deal with as well. And you know, we'll keep you all posted as that goes along. The FTC, as you know, has made several efforts along the way when they see something that's being done to send letters to the various dental boards or legislatures to say, we think that's anti-competitive and you should stop it. Bill Calnon and Mike Graham and a group of us went to talk to the FTC back in February last year, just to make sure they understood our position and to make sure we weren't set up as their enemy, and then said, let's work together on some of these things. But at that point, we made a little headway, but what's going on at that point? But they are on a mission on some of these respects, and it's very difficult to get them off of that mission. We're hopeful we can do that. So we'll keep trying along that way. I know what I was going to say is that we were told in that meeting that when they send these letters out, as opposed to going on an enforcement proceeding, what these are is really policy letters expressing the opinion of the FTC, and they really aren't meant to be coercive. They're meant to just express an opinion, and if you have an opinion back, you should voice it back to us. And we said, boy, I don't think that's the message our people are getting. You know, they get a letter from the FTC and they view it as, if you go forward with this, we're coming after you, and they back off. And so there have been a couple of instances in Georgia where that happened. I think in Maine, one of the legislators up there asked the FTC to send an opinion on some stuff that's going on up there. So they're continuing to keep an active role, but we're hopeful that this will be kind of the place where we can stop them and maybe slow down the process a little bit. So we'll see where that goes. The third thing I would mention, I'm maybe running out of my time here, I'll be very quick, is social media. You may have all seen in the paper or elsewhere or seen conferences that social media is a huge issue for everybody right now. And where it concerns the healthcare professional is that we're getting a lot of reports, not a lot, we are getting reports from our members that patients on Yelp or Dr. Google or other avenues are coming out and criticizing dentists or writing reviews of dentists the same way you would write a restaurant review. This is going to be a fact of life probably from now on and something we're going to have to deal with, but we're trying to get a handle on the best way to respond to those. You may have heard of situations. There was a Dr. Wong in California whose patient, actually the father of a patient, posted a negative review. Dr. Wong didn't like the review and so sued the father, claiming that it was defamation. Well, first of all, let me tell you that defamation or libel or slander is very difficult to prove. It takes a misstatement of fact, not a statement of opinion. So if the person walks out and says, I think this guy did a bad job, his staff was very rude to me, that's my opinion, you're going to have a hard time having an action taken against that individual to stop that, because that's what free speech is all about. You express an opinion. Dr. Wong filed a lawsuit. In response, the defendants, Yelp was also a defendant, but because Yelp had refused to pull the review, but really didn't have a whole lot of liability there. But in defense, they said, you know, not only did we criticize Dr. Wong, we also mentioned that she was using mercury. And so, therefore, that's the issue. And there's a statute in California and a number of other places around, other number of states around the country, I don't know if Virginia has one, but it wouldn't surprise me, called an anti-SLAPP statute. SLAPP is an acronym that deals with public policy, stopping litigation against public policy, something like that. So if the court finds that you brought your lawsuit to inhibit free speech, not only do you not prevail on your lawsuit, you may be the one who ends up paying. And Dr. Wong ended up paying $80,000 in attorney's fees for the defendants that she brought the action against. So if you decide to go that route, be very sure of what you're doing. There was also a case that I know the pediatric dentist may be especially familiar with, and that's Dr. Dove. Dr. Dove was a dentist in California. Same kind of thing occurred. A father of a patient went online to say, boy, this was a horrible experience. Dr. Dove was strapping down my child on board. It was a terrible thing. He was catatonic when he came out, blah, blah, blah. In that case, a number of other patients came out of the woodwork to support that view. I think Roger said also that Dr. Dove set up I didn't recall this for sure, but he set up a website to kind of counter this. But all of a sudden, out of the woodwork, all these people came on to say, no, this guy's right, this guy's awful, he's a horrible dentist. And it was just cascaded to the point that at one point he had 200 people outside his office demonstrating against him. So, you know, it's one of these things that we have to deal with. There are ways to do it. We suggest that if you get one bad review, I mean, if you're a really bad dentist and you get a lot of dentists, you should just hang up your practice and not worry about it. But if your practice is good and you have one dissatisfied patient who puts the review out there are some things you can do. There are groups now called that are reputation managers. There's a group called reputation.com that if you have that issue, they'll say, look, we'll go on and we'll do some things online that they're not illegal, they're not unethical, but there are things to kind of paper your reputation. We'll highlight the fact that you've gotten these awards or these other positive reviews, and what we'll try to do is drive that particular review down the board on the Google site, so it doesn't come up as the first thing you see every time you're out there. We'd also recommend, you might want to have satisfaction cards for your patients so that gives them an avenue to criticize what you're doing without going online to do it, or to give you a positive review. There's nothing unethical as long as you don't coerce it, to say to the patient, if you really, if the person says, you did a great job on me, or I really enjoy what you're doing, to say, if you really do, I've got a bad review on Yelp, and it wouldn't be a bad thing if you would put a positive review on for me. I'm not saying you have to do that. It's not a condition of anything, but free will. Just to let you know that's out there. And if you can get those positive reviews, you might be able to subsume the negative ones. Because the one thing that people who rely on these websites know is that you're going to get some negative reviews from time to time. And you're going to compare the ones that you've got. You're going to compare your personal preference and your personal experience. So it's not going to be that they're going to react to one review. But it is something that we know from experience from the dentists we've talked to, there is an automatic emotional reaction you're going to have when you get a bad review on one of these sites. And you're going to want to jump up and you're going to want to take the action. There is also what's called, the whole area now has generated its own vocabulary. And there is one term that I was sharing with Roger and Kurt the other night, which is the Streisand effect. Now, I don't know if you know about the Streisand effect. I didn't. But one of the experts in this field said that a few years ago, someone took a picture of Barbara Streisand's house on the ocean, and a very distinctive house, and was putting it on the internet or doing it for various purposes. And Barbara Streisand took great exception to the fact you've taken a picture of her house and we're putting it on the internet, so she sued. And no one knows the outcome of the suit. Because what they do know is this generated such a flurry of negative publicity against Barbara Streisand because she had this huge reaction to somebody taking a picture of her damn house that everything else was lost in the process. So the Streisand effect is, you may generate more as a result of your actions than was generated by the negative action that you saw in the first place. So again, it's one of those things where the first thing to do is take a breath and figure out how much harm is really being done. When I was at United, one of our customers, Jinder, had put out a website called untied.com. Well, Untied, if you type United enough times, as I did when I was there, occasionally you'll hit Untied instead of United, and you'll get the wrong website. And you'll find soon that it's a very negative website about United Airlines. Criticisms of everything you can imagine. And people in my organization came to me and said, what can we do about this website? We've got to get this thing taken down. It's defamation, it's libel. I said, well, first of all, you're going to have to tell me why it's defamation, why it's libel. They can criticize it all they want. And frankly, if you're in the airline industry, I think you're used to being criticized. I don't think there's anybody here who hasn't had a bad experience with an airline. So I said, if you're going to do this, how do you want to do it? So the VP of Safety and Security said, I want to write a letter to him because he's criticizing our safety and security. I said, fine. So we drafted a very nice letter. And the guy puts it on his website, paragraph by paragraph, with a commentary under each paragraph, saying, no, this is bullshit. This is awful. And I said, what did you accomplish by this? And it goes back to a quotation that I share often in this regard by Mark Twain, who said, never pick a fight with an entity that buys ink by the barrel. Because you're not going to win the fight. You're playing in their sandbox. So ultimately, I said to our people, I said, you got to figure out how much harm is being done here versus the benefits you'll get by pursuing it. Because how many passengers are we losing? You can't tell me we're losing many passengers through this website or that it's costing us business. It's just emotionally difficult. So sometimes you just have to take a deep breath and say, so be it. But it's frustrating, but there are some wrongs for which there are not remedies. That's the issue. So that's the three kind of things I wanted to hit for you today. There are obviously other legal issues that we're trying to take on for you. If anybody has any questions, I'd be glad to try and respond. If not, I give you this. So if you have a question, please. But I would say this. If you have something that comes up at any point, anything you have any questions about on the legal side, give me a call. I pick up my phone. If I don't know the answer, I'll find the lawyer in our group that can talk to you about it, and we'll talk it through. But I do want to continue to make that point that we're here for you. We're a resource for you. We don't view ourselves as an entity into ourselves, and we wouldn't exist if we didn't have members. So we're delighted to try and serve you if we can. Yeah.
Back to if you had a corporation of 1,000 dentists, they could actually go and do whatever they wanted to individually with an insurance company.
They would be able to
have
negotiate.
all those dentists.
Yes, because you have a single entity that's working.
So what would define that organization? Common payroll? I mean, what?
Common payroll, common risk is what they really look at more than anything else. They want a shared risk so that if somebody sues one of your dentists, you're all going to be sharing that risk and probably having to either pay the insurance premiums for that or pay for that judgment when it comes out. That's the main thing they look at. But they're going to look at, there are some definitions in some of the materials as to what they consider to be integrated in terms of integrated procedures, payroll, integrated contracting process, that kind of thing.
Because some of these corporate companies are kind of somewhere between dentists being somewhat independent, but part of these corporations. I wonder if any of them tried to approach en masse on the benefit of all their
I'm not aware of
insurance
it.
companies to try to negotiate fees.
I'm not aware of it, but that would certainly, I would think that's one of the reasons you band together. One of the reasons you get together is for that ability. Other things you get together for are group purchasing arrangements, things of that nature, and that's also addressed in the
Because we know the major health systems,
forget it.
they argue for years over what the payment's going to be before they sell the insurance company.
Yeah, absolutely. No, it's true. It is true. Anything else? Anyone? Yeah.
Can an insurance company say, one of the issues that we're going up with right now with the new contract, if you are not a provider, they will, if you're not a participating dentist, they will pay you at 50% of the URL. Well, that 50% of the URL, then the patient does not receive all of their benefit because the number is so low. Can they take that money away from the patient?
It's basically a contract issue, I think, is what you're talking about. They have the rights that they have according to their contract and then the contractual provision that covers that particular patient. So maybe I'd have to look at it specifically to be able to tell you what rights they had and what restrictions were on them. But if nothing else, I thank you for your time. It's been a real pleasure being with you.